state of Illinois apologizing and Cook County defending a controversial statement in a filing around the concealed carry mass transit prohibition case that's in the Northern District of Illinois and being appealed to the 7th Circuit U.S. Court of Appeals. Fascinating, as we've got a hearing set for this afternoon in the Northern District Court to delve into this. Welcome in Illinois in Focus Daily. I'm Greg Bishop, and like, subscribe, hit that notification bell for America's Talking Network, where you can wake up with us each and every weekday morning, 8 o'clock Central, and you can join that live chat as people discuss the news and their views. I'm here to just give it to you as we see it in the news business and breaking things down for you so you can stay plugged in. So let's just get to some background here. All right. First off, this case, Schoenthal versus Cook County and the state of Illinois, it was filed back in 2022, and this challenged the state's prohibition of people with concealed carry licenses being able to carry their concealed firearm on mass transit. Illinois approved back in 2011, 2012, the last state in the nation to allow individuals to carry firearms outside the home. This was after a series of lawsuits that went all the way up to the U.S. Supreme Court, essentially saying you can't prohibit people from being able to keep and bear arms even outside the home. So Illinois did not allow for any kind of carrying of firearms by law-abiding citizens. So Illinois being the final state to do that, they had options, of course. They could have just had constitutional carry, which they were given a deadline. If they didn't pass some kind of carry law, it would have been open constitutional carry. But instead, they decided to go with a shall issue law for concealed carry. And with that involved training and applications and licensing and the like. But it also spelled out the different places that you could not carry, right? You had prohibition of carrying in public parks. I believe there's a challenge in the courts concerning that. You also have the prohibition of carrying on mass transit. That's the case we're talking about now. In the Northern District of Illinois, a lawsuit filed challenging that. So ultimately, briefings filed. A district judge, Ian Johnston, he issued his order, and that order spelling out that the prohibition was a violation of the Second Amendment to the U.S. Constitution. Just to revisit the story we have today at thecentersquare.com, and on the Illinois page, you'll see Illinois apologizes for implying judge's transit carry ruling brings safety implications. But I wanted to get to what the judge ruled in this case, ultimately saying plaintiff's proposed conduct, carrying concealed handguns on public transit for self-defense, falls within the presumptive ambit of the Second Amendment, shifting the burden to the defendants to show that the Firearm Concealed Carry Act's ban falls within the historical tradition of firearm regulation in this country. And that's a reference to the, Bruin decision, the New York State Rifle and Pistol Association v. Bruin decision that was released in 2022, saying that gun laws have to fit the text, history, and tradition of the Second Amendment. But as this case was decided in the district court, the state decided to appeal that. And in a motion, they said that the potential safety implications of the court's order are highlighted by a recent mass shooting on the CTA's Blue Line, in which 4 people were murdered with firearms 3 days after the court's order was entered. Judge Ian Johnston demanded whoever wrote that answer questions during a hearing that's set for this afternoon, Wednesday, today. So Johnston looking for specifics on what they're supposed to be answering. He says, for example, and by no way limitation, counsel should be prepared to articulate the reasonable inquiry that was made to determine if the suspect in the CTA's Blue Line shooting possessed a concealed carry permit, and if so, whether he brought the gun on the CTA to properly protect himself. Moreover, counsel should explain the reasonable inquiry as to how the suspect was protecting himself from the sleeping homeless people when he allegedly shot them. So we've got now the comments from the state, and also yesterday, Cook County responding ahead of Wednesday's hearing. But let's revisit what Governor J.B. Pritzker said about the initial ruling from the judge, who said that the prohibition of concealed carry on mass transit is unconstitutional.
It'll be disappointing if they uphold this, but I'm hopeful that the law that was passed in Illinois a number of years ago that's frankly done a lot to keep people safe will be upheld.
So he says it's done a lot to keep people safe. But let's go over to what the state of Illinois had to say in their response ahead of Wednesday's hearing. We'll pull up the court filing here and read through this with you. So it says on September 25th, the court issued an order raising question about the inquiry counsel conducted to justify the following sentence, which appeared on page 8 of the motion to stay summary judgment. Moreover, the potential safety implications of the court's order are highlighted by a recent mass shooting on the CTA's Blue Line, in which 4 people were murdered with firearms 3 days after the court's order was entered. The court set a hearing date for today and ordered the counsel be prepared to explain the basis for the sentence and show cause as to why its inclusion in defendant's stay motion does not violate Rule 11. I believe Rule 11 means they have to do a reasonable inquiry into statements they plan on making. So the state's response to this goes on to say, though the quoted sentence, the undersigned counsel aimed to argue that a stay in the court's order is justified by the public interest in maintaining public safety. We're going to revisit that because, again, the Bruin decision says text, history, and tradition. From all indication I've gathered, that means that the balancing of interests no longer is applicable. But anyways, the court's order, which by its term applies to only the 4 plaintiffs, has already been misread to extend to others. The confusion caused by the misreading could result in an unintended increase in firearms carried on public transit in the future. Undersigned counsel intend to communicate that this order, therefore, raises potential safety implications that support the requested stay. This conclusion was based on counsel's knowledge of the documented connections between legal changes that tend to have the effect of increasing the prevalence of firearms in public places and increased public safety risks. The sentence was not intended to suggest that the perpetrator of the Blue Line shootings held a concealed carry permit, acted in self-defense, or engaged in conduct permitted under this court's order. The sentence also was not intended to state, suggest, or imply that this court's order was responsible for or specifically related to the shooting referred in the stay motion. And counsel apologizes if any such inference was mistakenly created. So the state apologizing to the federal judge. They go on to say, rather, the shooting referenced in the stay motion was cited solely as an example of an extreme harm that can be associated with a greater prevalence of firearms in public spaces, and to argue that the potential for such extreme harms, combined with documented confusion regarding the rules applied to firearms in those spaces, merited keeping the challenge statute in full effect while the appeal proceeds. For that reason, and for the additional reasons addressed below, and they go through some background, the court should not enter any sanctions under Rule 11. So that's the state's response to the hearing that we're going to be having this afternoon in the Northern District Federal Court. But what about Cook County's response? Here's what they filed yesterday afternoon, leading up to today's hearing. So we'll read through this. Defendant Kimberly M. Fox, in her capacity as the state's attorney of Cook County through her undersigned counsel, is responding to the order dated September 25th. All right, so it goes into, the court seeking clarification about that sentence. The order requires the signatories of the motion to appear before the court, and we'll have that today. Undersigned counsel hereby adopts and incorporates the background and legal standards set forth in counsel for the state's defendants. It goes on to say Rule 11 sanctions are not justified here, as undersigned counsel's conduct was reasonable in adopting the state defendant's motion to stay judgment and the arguments made therein. Brief moment here to kind of help, explain some of these, terms like stay. So the district court issued an order, a judgment, essentially saying that the prohibition on concealed carry mass transit violated the Second Amendment. All right, so that judgment essentially saying it cannot be enforced against individuals in the lawsuit. When there's a request for a stay, that essentially means they want to make sure that that order is not going to be in effect while they appeal. So that's what a stay is. They're trying to not necessarily reverse, but temporarily suspend the actual action from that order. So that's what a stay is. Regardless, let's get back to this Cook County response here. So it says, Rule 11 sanctions are not justified here as the undersigned counsel's conduct was reasonable in adopting the motion to stay the judgment and the arguments made therein. Undersigned counsel did not interpret any statements to be objectionable or to have been made in bad faith. The response from Cook County to the judge demanding answers as to why that sentence was there and if it was a violation of Rule 11, meaning they had to do reasonable inquiry to look into if the assailant in that murder, quadruple homicide, had a FOID card, had a concealed carry permit, was carrying it in self-defense and murdered those people in self-defense. Those are the things that the judge says, hey, come to the court and tell me if you did this reasonable inquiry. While the undersigned counsel cannot speak to the intent of the drafter, Cook County says, she can speak to what she believed the sentence meant when she adopted it. The sentence appears in a section of the brief which argues that the public interest overwhelmingly favors a stay for the judgment. One of three factors courts look to when determining whether a stay is warranted. Again, public interest. Is that something to balance here anymore in these types of cases? Undersigned counsel interpreted the sentence in question to state, one, that the court's order granting judgment for plaintiffs may implicate public safety because it allows plaintiffs to carry firearms while on the CTA and certain metro lines, and two, the shooting on the CTA Blue Line, which occurred, highlights the community fear raised by firearms on public transit. Gun violence is a very real concern to the people of Cook County, and the fact that a mass shooting occurred on the CTA Blue Line shortly after the order issued highlights the very real gun violence problem faced by Cook County residents. Undersigned counsel did not read the sentence in question to imply any causal connection between this court's order and the subsequent shooting, nor was it counsel's intent to make such a logical leap. Because no causal connection was implied, the undersigned did not find it necessary to engage in any inquiry as to whether the Blue Line shooter had a concealed carry license or whether he was acting in self-defense. This is coming from the Cook County prosecutor, the Cook County State's Attorney's Office. You've got an assailant and you're not going to find out if they have a concealed carry license when they're carrying a firearm on mass transit. You would think that would be an additional charge on top of the quadruple murder. But anyways, back to Cook County's response here. Those facts were not revealed or relevant to the mere fact that a shooting occurred on a CTA train short time after this court's order was issued, thus highlighting the potential public safety concerns related to the increase of firearms in mass transit. The undersigned believed the sentence supported the argument that public interest favors a stay of judgment where the judgment may have public safety implications and is a matter of great public interest. The undersigned has been lead counsel on cases involving the Second Amendment for many years and is aware of the connection experts draw between decreasing regulation of firearms and the increase in crimes using firearms. Therefore, the undersigned counsel believed that the sentence in question was appropriate in the context of the public safety argument. They say Rule 11 sanctions are not warranted. The undersigned's conduct was objectively reasonable in that no further inquiry was needed into the factual and legal basis for the claim asserted, which was merely asserting that there may be public safety implications in an order that permits individuals to carry firearms on the CTA and metro lines. Well, it's not just any individual. It would allow for individuals who have a concealed carry license, who go through X number of hours of training, who probably attend the range regularly, who have to pay a fee to have the rights to concealed carry in the state of Illinois, who have to, in some instances, give their fingerprints in order to have concealed carry. I believe all instances, right? Or is that just you can get it quicker if you have fingerprints? Or is that the FOID card? I'll have to go back and review that. Some of you can correct me in the comments as you typically do, which is great. It's kind of crowdsourcing, fact-checking here, so appreciate that as well. But regardless, this isn't for everybody. Right now, the judgment's only for the individuals who sued. Illinois State Rifle Association looks to actually, increase or broaden the ruling to impact everybody who has a concealed carry license. But to this issue of saying that the ruling in the sentence they're targeting here in this hearing this afternoon, rather fascinating as we hear from Richard Pearson and from the Illinois State Rifle Association, his interpretation of what the defendants in this case are really trying to convey.
Well, the state's trying to say a criminal act is they're trying to say that if you carry on mass transit, it would lead to more things like this. But the fact is, those are criminals doing that. We're talking about armed citizens protecting themselves and others. It's a completely different story.
So the issue as well about balancing public safety, as you heard me reading the Cook County response ahead of this afternoon's hearing, they're saying, hey, we made this statement to provide our thoughts on how public safety could be in danger because of such a ruling, allowing for people to carry concealed. Here's Governor Pritzker several weeks ago talking about the balancing of public safety.
You know, there are misguided judges who are making decisions that I think are inappropriate and do not hold dear public safety the way that we do.
And Richard Pearson saying that the standard now in the Bruen decision that's now precedent from the U.S. Supreme Court for Second Amendment cases doesn't necessarily talk about public safety.
What Bruen actually said is you got to follow the law. You know, you got to do what Heller said. You got to do what McDonald said. The power of Bruen is actually just saying you've got to do it this way. There wasn't anything that phenomenal in Bruen other than the fact that you have to do it the right way. And so some district courts have been wandering off the reservation, and they're going to get reined in, I believe.
So this afternoon in the Northern District's courtroom of federal judge Ian Johnston, the defendants are going to have to answer these questions. We heard a little bit of a preview from these filings, but if you want to see what's going on, I am going to tap into it and tweet out the proceedings. So go follow me on X, search Bishop on Air, and you can follow along as well, and we'll review it again tomorrow. It's right here with Illinois in Focus Daily. Like, subscribe, hit that notification bell for America's Talking Network. Get the podcast wherever you get your podcasts. And join us each and every weekday morning for Illinois in Focus Daily.